spent my 17 years. And 1 year, I did not earn a single paisa. I did not do any case in Calcutta High Court. Any private matter. I spent from my own pocket. This CBI has powerful because of my exercise.
That trial has been completed.
No, I am telling you, I was 90, no trial. 2001, 24 years, no trial. Rizanur Rahman, 2007, no trial. Sir, we are in the High Court. No, don't
continue. Sir.
please no. Don't pass any comments. Go stand there in that side. I'm arguing.
I am not passing any
What
comment,
side?
with due respect.
No.
Sir.
Don't do it.
I'm just
Don't-
assisting.
You assist there. Don't not within my ears.
No one have heard that I have.
Sure.
Don't show your arrogancy here.
Nothing.
CBI is arrogant. We know about that. Don't do it here.
All right, Mr.
No,
Bandyopadhyay.
I'm arguing this constantly. Tell your client, Mr. Majumdar, do not be afraid to your clients. Be a lawyer of High Court.
Yes, Mr. Bandyopadhyay.
Not can be said to be a faulty investigation, and therefore conviction order has been passed. I don't know whether the trial court judgment has been shown to your lordship.
No, that is not
They
what.
should have filed this subsequent event.
But one thing, Mr. Bandyopadhyay, you have also fought many cases. Do the statutory powers limit the constitutional courts?
Court cannot pass an order contrary to the statute.
No, this is not contrary.
Yes.
Whenever suppose these in the BNSS or in the CRPC earlier, there was no provision for giving investigation to the central agency. Otherwise, magistrates could have easily granted aid to the
No CBI.
now however sanction provision was there and under the DSP Act, and therefore under Article 226, when orders were passed, the permission of the state were also not required in those circumstances. Now, when the High Court takes into account all these materials, either under 482 or 226, whichever the powers are, is it that because proviso clause is because of Rita Nag's judgment, which I believe, to cover up the Honorable Supreme Court's judgment in Rita Nag's
This
case?
proviso was also earlier.
No, it was not there earlier. No, it was not there.
Earlier.
Not there.
It was not there earlier.
Not there.
This was because of covering up Rita Nag's
Yes, yes.
judgment. Now, we'll hear you. You will take a long time.
No.
You're not nice ones to argue.
Point
concluded the 20th
My lord,
January. Order was
excuse me,
passed.
sir. Kindly allow me to argue, please.
ठीक है आप इधर आइए.
See, point is, no, this is I argued that went up to Supreme Court that the constitutional bench has laid down the law, and it was my research for 17 years.
I don't dispute that, sir.
That's right. Point is, when an investigation is defective and when an investigation is conducted in a biased manner, whether the High Court is having the power to direct, to transfer the investigation. Ultimately, Supreme Court has said, yes, Article 226 and Article 32 of the High Court, power of the High Court and Supreme Court is there to direct the transfer of an investigation, right? Now, that is a pending trial. Even a trial is going on, even in that case also directed to make an investigation. Is there any case where the Supreme Court has said, yes, we have transferred it, trial has been concluded, even then we can direct to transfer. I mean, make an investigation. The constitutional power, what your lordship is saying, that is up to the conclusion of the trial. That means one judgment of, I will show to, I have a number of judgments. Just one paragraph will make it clear. Matters now. You see, this is a Madras High Court judgment, 2013 1 MWN CR 267 DB. Kindly come to paragraph just a minute. How much of it? 2013, one MW, আমি দিয়ে দেবো হ্যান্ডওভার করবো, একদিন সুন্দরকে দিয়ে দিবি। MWN CR 267 division is connected. The lordship will come and see the paragraph. Come to paragraph. এটা তো yes, come to paragraph 28 first. In Hansbai, Balibai and Kuresi and State of Gujarat 2004-5 SCC, in paragraph number 12 and 13 has been held as follows. Subsection 8 of section 83 permits further investigation. I was telling to Lord 173.8 earlier, which was there. Further investigation. There, no. CRP is the folder there, no.
No, further investigation
No,
was
there.
there.
I am saying,
The proviso
Proviso is
clause
not
was
there.
not there. The proviso part
and
which
it's same. Further investigation, when? When? Further investigation provision was there. Proviso has made it very clear.
proviso has-
Further investigation where? Magistrate, how long? Or investigating agency can keep it for how long? Till doomsday? Is it the law? No, I could not finish it. We have a voluminous document. We have to look into that. If an investigating agency cannot finish it, they are liable for everything. Interest is must to take over the investigation. But you can't conclude the investigation. Did Milord? Subsection 1 of the court permits further. Milord, I am very little knowledge in criminal law.
No, no.
I am arguing before legal luminaries, and others are also legal luminaries in the criminal branch. I don't know. Therefore, no, I have become nervous. Power is not there. I was arguing.
these cases you have done much more than others.
Milord, I have spent my 17 years. And 1 year, I did not earn a single paisa. I did not do any case in Calcutta High Court. Any private matter. I spent from my own pocket. This CBI has powerful because of my exercise.
That trial has been completed.
No, I am telling you, I was 19, no trial. 2001, 24 years, no trial. Rijanur Rahman, 2007, no trial. Then other cases, no trial, nothing. Only I have said in other case, Khichberi photo. That is only, no trial has not been concluded.
Trial is going, Vijay.
Going on, not concluded.
18 years.
18 years.
18 years.
They are claiming to be the prime agency.
I had a privilege to appear on.
But it is better to give a constable to the investigation.
That I will not say. But
Now let us see and come. Conduct proper even after the court took cognizance of any offence on the strength of police report earlier submitted, all the more. So if is in this case, the head of the police department also was not satisfied of the propriety of the manner and nature of investigation already conducted. Now, so and so it was observed by this court that further investigation is not altogether ruled out merely because cognizance has been taken by the court. When defective investigation comes, like come. When defective investigation comes to the light during the course of trial, it may be cured by further investigation. If circumstances so permitted, it would ordinarily be desirable that all the more, so in this case, that the police should inform the court and seek formal permission to make further investigation when fresh facts come to light instead of being silent over the matter, keeping in view only the need for an early trial, since an effective trial for real or actual offence found during course of proper investigation is as much as relevant, desirable and necessary as an expeditious disposal of the matter by the court. In view of the aforesaid position of law, if there is a necessity for further investigation, the same can certainly be done as prescribed by law. The mere fact there may be a further delay in concluding the trial, can't read it. Concluding the trial should not stand in the way of further investigation if that would help the court in arriving at the truth and through real and substantial as well as effective justice. We make it clear that we have not expressed any final opinion on the basis. 29. From the above, then, there can be no difficulty to firmly conclude that any state before the final conclusion of the trial court had got the power to order for further investigation. When the court is satisfied, the investigation is allowed. Therefore, after trial, magistrate is having power. My lord, if the Sir, we are in the High Court. No, no, don't
Continue, sir.
please no. Don't pass any comments. Go stand there in that side. I'm
I am
arguing.
not passing any
What
comment,
side?
with due respect.
No.
sir.
Don't do it.
I'm just
Don't-
assisting.
You assist there. Don't not within my ears.
No one have heard that I have.
Sure, sure.
You will ask
Don't show your arrogancy here.
nothing.
CBI is arrogant. We know about that. Don't do it here.
All right, Mr.
No,
Bandyopadhyay.
no, I'm arguing this constantly. Tell your client, Mr. Majumdar, do not be afraid to your clients. Be a lawyer of High Court.
Yes, Mr. Bandyopadhyay, please.
Now, therefore, my lord, what I was submitting. See, if the Mr. Majumdar says post incidents are there for that investigation is required, that's a completely new case. No objection, nothing. I am not raising an objection. I am saying about your
Pass out.
point is, my lord, if the magistrate statutorily doesn't give the power. Law is that if an investigation is defective, court can direct. That's the fundamental. That is the my lord all cases. Even at the stage of the trial, it can be, if there is a fault, if the court says there is a fault in an investigation, court may direct for further investigation. And under the new act, when a further investigation has ordered to be directed to do, it has to be done within 6 months. Therefore, the point before your lordship is this: whether if the statutory power is not there, writ court is having the power. Can you revive the trial? If a trial cannot be revived, how the court can direct investigation? I have other judgments. I will argue on the next day. I've said I will have to leave. I have other judgments.
No, I know.
No, I have a very little knowledge in criminal law.
No,
I always scared in a matter when I appear, especially when Mr. Rajdeep Majumdar and Mr. Sudipto Maitri appear. When I was doing in the Rijanur case, I will not take the name of all the senior counsel appearing against me were saying we have to go to the law classes. I had to hear that comments also. But
height of humbleness.
Indeed, I had to hear that from the senior counsel who was appearing from the other sides. But unfortunately for them, fortunately for me, that I won't. But I must say, Miller, one of the senior counsel, that the great Bolai Rai, when I was arguing, almost on the last day, he came out from the court before the delivery of the judgment. He said to me, Kallan, I am happy that one lawyer has come. Even if I die, I will know that there is a lawyer in Calcutta. I am so grateful to him. They were encourageable, but today's legal luminaries tell me that I don't know the law. No.
They don't treat after getting senior counsels.
On the next day I will, and if possible, your lordship skip it at 4 o'clock or 4:15. It will be with your lordship's permission.
Yes, please.
No, I have said. State is saying.
No, I remember you have no on merits, you don't have any objection. But, you have submission, so as the law is concerned.
Law is concerned.
Well, then it is for academic
No, academic or non-academic, that's a different thing.
conversation.
See, on the instructions of the client, he has made his submission. As a lawyer professional,
Yesterday I said before the Honorable Chief Justice in a Jadavpur matter, I submitted. It is not the instruction of my client, but as a senior advocate, I feel that lordship should pass an order stopping all meetings within the Jadavpur constituency. Jadavpur means
University.
There should be a balance has to be created between a fundamental right and the normal public interest. Public is also enjoys the fundamental right. People have less to